Sir, thank you. Thanks for inviting me. What General Dunlop left out was I'm a sub. So if you are following the agenda as it was in development, you would have seen another Korn was supposed to be here speaking to you in this time slot, Jeffrey Korn. How many of you know of Jeffrey Korn? Yeah, plenty of you, I'm sure. So, I'm the second stand-in. It kind of reminds me, it takes me back when I was in 10th grade. I was brought up to play on the varsity football team to back up a guy named Rodney Cook at fullback, who was an all-American high school football player. He was phenomenal. And we went into the playoffs, and he had a deep thigh bruise and couldn't play. So then it was, Gary, we need you. Okay? And I was an adequate substitute, kind of in defense counsel terms. I was an adequate substitute for Rodney Cook. But I will say that I went on to start the next 2 years. I was, a recognized player in my time, and we took our team my senior year to the state, basically the number one ranked team in the New York State. So I was definitely a better football player than Jeff. But whether I'm a better substitute today is a bigger question. Let me also, like Lori, I do have an affiliation with the Office of General Counsel at DOD still to this day, so I'm not here in that capacity. They would never want me to say anything remotely related to anything. So, I'm here in my personal capacity. And what I am going to talk about it is part of the, I'll plug because I'm a fellow at the Lieber Institute at West Point. Hitoshi might be in the other room, but he's here repping. So the Lieber Institute has a book series. They're on the Lieber Studies Volume 9 is the book that I have a chapter in. I've written chapters in a couple of their prior series. And the title of the book is Big Data and Armed Conflict, Legal Issues Above and Below the Armed Conflict Threshold. So you can pick at that title a little bit of some internal inconsistency, but it's a good book. As always, they do a great job of pulling in great authors and some substitutes to write for them. And it was Laura Dickinson and Ed Berg who were the editors for this volume. And Laura reached out and asked if I and my partner in crime at times, Eric Jensen, who many of you may be familiar with, professor at BYU, former Army JAG, if we would co-author a chapter. And so we kicked around ideas like big data. What are we going to talk about? Well, it's big. I don't know. There's a lot of it. What are we going to talk about? And so, I teed up this idea about how big data was playing into current strategic competition. Dean Chang set me up well for this discussion. And I will talk about the chapter and what we kind of laid out in the chapter. It is a thought piece. Let me say that. We were clear that we are not advocating for a particular set of actions, for a particular policy. It is more of a thought piece that I'll expound on here as we go. So we came to this idea of within strategic competition, artificial intelligence. As I said, Dean set this up well. Dean's forgotten more about China since he gave his talk 2 hours ago than I will ever know about China. So I'll admit that. But certainly I've had some insights through my prior jobs and other things. And the sort of bottom line to it is within this realm of strategic competition that I'll tease out a little bit, we are in an AI race. Make no doubt about it. We are in an AI race, and it's extremely consequential. So what are we, how do we approach this? How do we deal with this situation? Now, I'm going to ask a question, because now I'm in a law school, and I do that. I have two of my students here. They're probably getting a little bit of, they had me last semester. Oh, my God, we have to listen to him again. This is horrible. But they're down here as Len scholars, so thank you, sir. But I can ask questions. So let's say you're down in lower Manhattan. It's a beautiful day. Everything's sort of normal. People are getting on their way to work and so on. And then there is, tragically, a massive, massive explosion. What do we think I'm talking about? Say again?
9/11.
No, you'd be incorrect. No, I'm talking in July 30th, 1916. Black Tom Train Depot, millions of tons of armaments, war materiel, stockpiled there, that suddenly exploded. Shrapnel damaged the Statue of Liberty. 3 men killed and a child killed. What was going on in 1916? World War I. World War I. Yes, ma'am.
I thought it was in Jersey City.
Well, Lower Manhattan, Jersey City. Don't mess me up here. Very nice. But she.
Jersey watched that one.
Yeah. But to be correct, it was Jersey City. So she's absolutely correct. That was the primary point of the explosion. Who do we think was behind this explosion? The Germans. Sabotage. We were not yet in the war. This was an effort by Germany to disrupt and impede its other adversaries from reinforcing their war supplies and materiel that we were helping with. Sabotage is nothing new. It's been going on. States have been engaging in sabotage for a long time. And what's interesting there, too, we know that this goes on in warfare. Just think of the Kirin 7, right? The German saboteurs who, the next war over, just came ashore on Long Island, where I'm from, and in Florida, et cetera, right? That was a wartime effort, attempted sabotage. But obviously, the Black Tom affair was outside of warfare. States have used sabotage over time in history as a tool of statecraft. So, what does this have to do with artificial intelligence, you might ask? He's talking about stuff in 1916. Sabotage, there's no agreed upon definition necessarily. It's actually part of counterintelligence mission set, right, to counter sabotage. But we can, generally understand the definition we settled on in the book. We refer to the meaning generally ascribed to the term in the context of state-conducted or sponsored sabotage. Actions intended to impede a state's ability to prepare for or participate in war or national defense or otherwise present a national security threat by impeding through interference, subversion, obstruction, damage, or destruction the development of its military or other potentially threatening capabilities. Okay, so AI. You heard Dean talking about it. You can't swing a dead cat these days. Am I allowed to say that anymore? What you can say, or am I offending cats? You can't swing a dead cat, or at least an inauthentic, artificially generated dead cat. How about that? You can't swing them these days without hitting, the discussion of AI. It's everywhere. It's ubiquitous. It exploded on the scene last year, essentially. It's been around longer to the extent that it is truly artificial intelligence, right? But we've seen it with ChatGPT and et cetera, et cetera. We see how it's now starting to invade into areas of influence, disinformation, deepfakes. We could go on, okay? Here is, I saw this is a great quote. I'm looking at, part of this we drew out of the NSCI, the National Security Commission on Artificial Intelligence, put an extensive report out in 2021. It's a great document. Jason Matheny, if some of you know of Jason Matheny, I'll come back to him when I close out and fill in the gap on who he is, but he was part of that. Here's a quote they pulled from Thomas Edison when he was talking about electricity that they say encapsulates the AI future. It is a field of fields. It holds the secrets which will reorganize the life of the world. It is game-changing. I wish I really understood it. It is game-changing, though, when we're seeing this. I'm at the tail end of all this. I think about my kids and what the world's going to look like 20 years from now with this capability. But there are huge national security implications to this, right? There's obviously positive use cases. There's obviously like non-military, non-national security. It's a quintessential dual-use technology that can be incorporated and used in a variety of different ways. But there are profound national security implications, right? So the end sky, AI-enhanced capabilities will likely be the tools of first resort in a new era of conflict as strategic competitors develop AI concepts and technologies for military and other malign uses. Dean focused on some of those that are already starting to happen. The information space and China's approach to the information space and how it's engaging in what I would call information conflict outside of warfare presently, and how this is playing. So, we've seen this starting to play out. And another step back, where does this fit? Well, strategic competition. We were talking about it in terms of great power competition. We saw a shift in the language a little bit with the current administration. The basic premises are the same, though, right? Strategic competition. China is the number one pacing threat for the United States. You see this in all the intelligence assessments, et cetera. According to the U.S. intelligence community, China is challenging the United States in multiple arenas, especially economically, militarily, and technologically, all as part of its steady and increasing push for global power. China is engaged in a multi-front effort, including through ever more aggressive gray zone tactics, to undermine the U.S. global influence and competitive advantages, drive wedges between the United States and its allies and partners, and disrupt the rules-based international order in favor of establishing international norms that align with Chinese authoritarian interests. That's part of the intro to our chapter that Eric and I wrote, and I feel a lot better because I heard Dean say many of the same things in his presentation earlier today. So my guesses at China are aligning with his knowledge. But within this strategic competition, China has absolutely recognized that AI is a game changer. Right? They've, I think, put 2030 as a mark on the wall of being the world leader in AI. Here's a quote. Artificial intelligence is the future, not only for country X, but for all humankind. It comes with colossal opportunities, but also threats that are difficult to predict. Whoever becomes the leader in this sphere will become the ruler of the world. Now, a bit hyperbolic, right? Who do you think said that? Vladimir Putin. Who read my chapter? Cheater. Vladimir Putin said that in 2017. So another pacing competitor recognizes this. It is a central front in this competition with China, certainly Russia as well, but primarily China, right? So they have this publicly announced strategy, and they see it as an offset technology. They see it as a means for leapfrogging over the United States in our advantages militarily, et cetera. So, okay, big data. What's the connection? Again, thank you, Dean, for helping me out. Like he set this up. AI, I am not an AI expert in the technology, but I do know this, and I stress tested it with people at the Center for CSET over at Georgetown, Center for something, Science and Technology. Anyway, they're doing deep AI studies. There's some great folks over there. Retired Air Force General Bansimer is leading that effort. But AI depends on big data. You can't have too much data to develop AI. You have to have the right data. It gets a little bit more nuanced as the AI develops. We are still in the realm of what you would call narrow AI, not general sentient AI, but it's still quite powerful, and it's starting to make its way into all sorts of military systems and capabilities. Okay? Think of drone swarm technology to be used against our naval assets in the South China Sea, and how that can be a sort of game changer in that area of conflict. So quantity and quality matters. But here's the thing. China is awash in big data. If you're thinking about competition, if you're thinking about a race here, part of it is the the human capital to develop the technology, the compute power to develop the technology. There's a whole bunch of components. The NSCI says we do hold advantage in a lot of areas. But one area where certainly I would say China does have competitive advantage is in the area of data. It is a surveillance state. Let's not kid ourselves. And it's not just a surveillance state within its own territory. China is obtaining data left and right. I won't go off on the TikTok tangents and tell you why you should not have that on your devices and kick your kids off of TikTok and et cetera, et cetera. But they have that competitive advantage. So I'd say the primary thrust of the NSCI recommendations is we should outcompete. We should outcompete through investment in innovation, investment in human capital, et cetera, et cetera. All good. Don't disagree. But is that enough? Should we be thinking about other options? And I come back to the question of, dare I say the word, sabotage. If their competitive advantage is the data, the old adage of garbage in means garbage out comes to mind. If, and there's lots of ifs built in this. This is a thought piece built around a hypothetical, right? It's not an actual set of facts that lawyers want to ultimately get their hands around so you can really analyze. But were we able to gain access to some of those data sets? Could we engage in what's called adversarial AI? And a specific type or component of adversarial AI, you've heard the term data poisoning out there. It's certainly realistic enough that in the recent US, the president's executive order on artificial intelligence, that is a plank in there that we have to make sure our own cybersecurity is sufficient to protect the data and AI algorithms that we are developing. Right? So the executive order on artificial intelligence. So this is not just theoretical, there are possibilities here. Okay, so then maybe that's something at some point that there could be a policy decision that we need to impede our adversaries' ability to develop this technology, certainly in the military realm. Okay, so what are the international law implications of this? It is a Lieber series book. It was about law. We probably should get to that at some point. So what are the international implications? In many ways, it just sort of raises up a lot of the same difficult questions that have been percolating now for maybe a couple of decades around cyber and cyber operations themselves. Okay? But it's interesting because it brings a focus on preemptive action, arguably preventive action. For the lawyers in the room, we are familiar with the notion of, in terms of self-help remedies in international law, there's only one area where you can act anticipatorily, right? Which is in the realm of self-defense. Anticipatory self-defense. So you have to sort of unpack, is this a self-defense action you'd be engaging in? Well, the core premise to that is, what are you doing in the first instance? Are you engaging yourself through this cyber operation, through data poisoning, in a use of force that would be otherwise prohibited under Article 2.4 of the UN Charter or customary international law? My students are in the room, and they know that I pounded away at them to say, when you are a legal advisor, when you're playing the role of legal advisor in a national security setting, and your operators come to you with a proposal, do not start asking yourself first, what's the adversary doing, or what has the adversary done? Right? Right, Lauren? Yeah, see? Right? We know what we are proposing to do. We need to assess whether it itself would violate international law. So put your hands over your ears, because I'm going to violate my own direction. We started talking about the sort of preventive aspects of this first. So the justification in international law of self-defense, of course, that assumes that, as I said, the operation will be a use of force. I'll come back to that. Because our determination was, more than likely, a data poisoning operation is not going to cross the threshold in international law of being a use of force. Okay? But there's some interesting aspects that you can pull from this. If you look at the notions of self-defense and anticipatory self-defense in international law, there has been some change over time. The Caroline case, the Caroline standard, is always the one that international lawyers gravitate to. Everyone can sort of agree on that, right? Instant, overwhelming, leaving no moment of choice. A very, very, very tight imminency requirement in international law. Then again, we've seen actions over time like the Israeli operation to strike the Osiris nuclear facility that they asserted under the then Begin Doctrine as an act, a quintessential act of anticipatory self-defense, and the world community said, no, we condemn it, we disagree. But advance the ball, how you doing? Advance the ball, operation outside the box, right? The Al-Kabar nuclear facility in Syria in 2007. And when it was learned that that was, it was another Israeli strike, world reaction was muted. There was really no condemnation of that. Even Syria didn't call it out. So we see this, we saw this, it manifest in the so-called Bush Doctrine that got sort of pulled back a little bit with, some would say, invoking it incorrectly as part of a justification to go into Iraq in 2003, et cetera, et cetera. But look at our rules of engagement today, our standing rules of engagement. Imminence does not necessarily mean immediate. So there's been some expansion in understanding of what imminence is, at least when it comes to extremely consequential risks from a national security threat. When you're talking certainly WMD, when you're looking at nuclear weapons, et cetera, there's a sense that your window of opportunity is different, and we can't compare that to the circumstances in 1837 when the Caroline affair came out, where the maximum effective range of your most lethal weapon system was maybe, I don't know, a half a mile, right? Now, whether that carries over to a technology like AI, is that as consequential? It's a component to different weapon systems. It's a component to decision support systems. Maybe that's a little bit harder to draw. So where we would be sitting in the immediacy question is one of the things that we sort of teased out in this chapter, and certainly left some open questions, but it's something to be thinking about. And you can look at, a number of follow-on actions that drive this. So the whole sabotage question, it's not just very physical manifestations that we've talked about. This migrated in the 1980s into the virtual world. Has anybody heard of the Farewell dossier? We learned through sources that Russia was stealing, because they couldn't produce it on their own, they were stealing a lot of computer components, et cetera, right, from the US. And so we devised a plan to perhaps have them poison that supply chain of computer things that they were stealing, and they would bring back infected devices. And they did, and it led to a pipeline failure and some other problems in the Soviet Union. This is what a guy named Fred Arquilla, who has written several books in the cyber realm, he was a senior policy person at DoD, et cetera. I didn't coin this phrase. He brings it into the world of sabotage. That's kind of cool, right? Sabotage. So there's plenty of other examples we could peel back. So then what is the preventive action, sabotage, international law, maybe what you could call is the left of boom law, or the left of boom, boom law. That might get really dangerous if we go down that road. But all right. So, like that start point, as I said, is the jus ad bellum question. Analyzing this through the lens of whether or not what you're doing is a prohibited use of force. If it is, do you need that? You need that justification in international law. Can you make out a case for a preventive or preemptive use of this tool or this stratagem in international law? But again, this is premised on whether or not it's a use of force. You know, when I was talking about this talk with now Professor Dunlap, what do they call you, Professor here?
They call me Your Highness.
Your Highness, His Highness Dunlap. You know, he asked me to touch on it. And actually, we did in the chapter. It's kind of interesting. This is an outside of armed conflict discussion, right? This is a law of international law that applies to situations outside of armed conflict where we're seeing this strategic competition take hold and play out, but not an in bello, not a law of armed conflict discussion. There's something sort of interesting, though. Within the Talon Manual, within international legal discussions, et cetera, there's been mostly a focus in assessing force in general on the jus ad bellum questions of what amounts to an attack under the law of armed conflict. One piece that has derived out of that is, although there's been some pushback by some states, the Talon view, other states have come out in a very, very strict positivist interpretation of international law and said data is intangible. And as something intangible, it doesn't qualify as an object. Therefore, it cannot be made the object of an attack, an act of violence under the law of armed conflict. So all of the panoply of targeting rules that come into play in bello wouldn't apply to operations that poison or corrupt data. Does that translate over to the jus ad bellum discussion? Also, there's a question of, what is an act of violence under the law of armed conflict? Loss of functionality to a system, a machine, a computer, is that enough? Or must you do something that's going to cause sort of a rip and replace moment? That your operation is physically damaging in some way a computer system, a network, a device. That is sort of where the consensus sits. And on the edges of loss of functionality not amounting to actual physical damage, there's some expanding views on that. But again, what does that have to do with interpreting jus ad bellum and the notion of use of force under the UN Charter? It's in some ways you should say it's irrelevant. It's a lex specialis over here. It's got very specific treaty terms with Travaux behind the treaty terms, et cetera. And really what you're looking at in the use of force phase is the ultimate consequence on the victim state. And so, yes, the sine qua non of use of force has similarly been over time in history, use of armed force that results in kinetic consequence. You see it in the DoD Law of War Manual, others. If it kills people, injures humans, damages and destroys things, yeah, that's probably a use of force, but it's not limited to that. And states have begun to recognize that sort of, for example, the Netherlands, France, some others, a cyber operation that has severe impact on financial systems and the financial sector may end up being considered a use of force. So there's a lot to sort of unpack there. I'm going to, for the sake of our time here, move a little quicker because, you say corn and hot take or short take, what is it?
Short burst.
Short burst and corn and microphone in the same sentence, they don't go together. So you should know that. But anyway, right, so again, the chapter's there. We concluded that it's possible, depending on the level of impact and consequence, how critical is the system that you're impacting? The DoD Law of War Manual also opens the door to a cyber operation that simply disrupts a critical logistics system for the DoD could be considered a use of force, right? That's logical. Think about it. If you take down critical command and control systems without physical manifestation, you have put the United States in a serious risk position. Could be a use of force. So it doesn't necessarily have to have physical manifestation, although that is historically where the world has sat. Okay, so probably not a use of force to do some data poisoning operations. Does that end the discussion? No. There are other rules of international law that apply outside of armed conflict, one of which is the rule of prohibited intervention. Can you intervene in the internal affairs of another state? Again, this ties up some knotty questions about where is the focus of your operation? Is it seeking to coerce some decision or action by the targeted state? Aimed at the states, we say domain reservé. It's core sovereign decision-making prerogatives. General international law says commercial activities don't fall within a state's domain reservé. So is this in a purely commercial research and development stage? Or is it closer tied in? And this gets more complicated when you have a command economy like China, where the separation between the public and private sector is not so clear. So as we looked at it, again, depending on where the AI is in its development cycle, how close it is, what type of system, how critical is it to that state's own national security structure, you potentially could trip up against the rule of prohibited intervention. And what is interesting there is, as a matter of self-help remedies in international law, there's a thing called countermeasures, otherwise unlawful acts that are justified, but consensus is, I think illogically, but consensus is that countermeasures, unlike self-defense, does not include anticipatory measures. So if you are determined, if you look at your operation, you say this would be a prohibited intervention, you don't have the option necessarily of doing it anticipatorily. And the last thing I'll say on this, and 5 minutes for questions is cool. For those who have been following these discussions in the cyber world, the elephant in the room, certainly for me, is this question of sovereignty. Sovereignty as a concept in international law, and the debate that's going on with states weighing in as to whether sovereignty is in fact an enforceable rule of international law or just an undergirding principle that drives some of these other rules. So we touched on it. I have long been in the camp that sovereignty is not a rule of international law. The United Kingdom is very publicly in that camp. The U.S. has sent signals but never given a full throated answer. But a number of states have come out to the contrary. So that's an open question that you'd also have to grapple with. Interestingly, Mohammed Halal at Ohio State University, I don't know if you know Mohammed, he'd be great to bring to your conference. He's former diplomat, legal advisor in the Egyptian Ministry of Foreign Affairs. He just did a project with the African Union where they put out a statement representing the views of all the African Union, and they were very, very draconian in their view of sovereignty. There's no operation that touches infrastructure maliciously is okay under their view of sovereignty in international law. So this is an evolving space, but you'd have to account for that, again, in assessing whether you could. But our bottom line was there are ways to thread the needle. There are ways to potentially conduct these operations that would be consistent with the U.S. legal obligations under international law. So I'll hold there for any questions.
Gary, that was really a tour de force, and I think you'll never hear with more clarity touching upon a range of international law issues that are, embedded in this whole cyber discussion. That is a tour de force. Thank God we have, videotaped it, because I got a feeling my class is going to have to watch it. So those of you taking...
Why do you punish your class?
Yeah. Well, it's fine. Yeah. No, and you are no substitute. I'm not going to let you get away with that. We do have time for maybe 1 or 2 questions. Bill, and then Riley.
Zachary.
Bill Wells, retired Air Force JAG. Question about training AI. There's an issue rattling out about whether that is a fair use under the Copyright Act, and if so, whether it should be a mandatory license to compensate the creators. If you'd like to address that on the competitive side of AI versus the places that don't honor copyright law.
Well, if you wanted to stump the chump, well done. Copyright law is not my area. That's not an international law question. I mean, there's definitely, we work side to side at my program with our IP folks. There's tons of difficult questions right now about the whole fair use issue, open access to information and data, how we're managing data more broadly. I think there are a ton of really important questions, kind of slide off tangent, even in the data brokerage market right now. And when data is a competitive advantage, why are we giving China such easy access to data through commercial means, as opposed to sort of clamping down on that in an arms export control fashion? So all of this has to be taken into account. I didn't really answer your question, but I said a lot.
Zach, you're going to get the last question. Riley, you can get it later.
Yes, sir. Thank you. So, my apologies. So, Professor Korn, my question is, as you're talking about anticipatory self-defense, we generally think of that only kind of being triggered by the imminence of an armed attack. But in this context, we're talking a lot more about kind of imminent either sabotage by near-peer threats or political threats. Can you talk a little bit about kind of the legal framework that gets us into the anticipatory self-defense realm without having to be concerned about an imminent armed attack?
No, absolutely, and it's very difficult to make this case. But what we sort of focused on is yes, right now we're in the world of AI generated political influence. It's political influence on steroids. It's disruptive, et cetera. That's a different framing in thinking about this. That's hard to qualify that as armed attack or imminence thereof. What we're talking about, though, is weapons capabilities, weapon systems, right? The development of hypersonics, et cetera, et cetera. So there's danger of getting in, those who've been to the war colleges, the Thucydidean trap, stage of this. But all our point is when you think about certain destructive capabilities like nuclear weapons, the notion of anticipatory has been stretched to preemptive. Ashley Deeks has done great writing on this, but nobody's willing to sort of bend so far as preventive, right? But it all still has to be tied to imminence of armed attack. But how do you assess that when you have a capability that is so consequentially destructive and your decision time is being condensed further and further? And one of the things that AI is doing is condensing the OODA loop, right? Our observe, orient, decide, and act loop in national security decision making. So. Okay.
Gary, thank you so much. Let's have a big hand.